India Legal presents Courts Roundup.
Hello, I am Disha and you are watching Courts Roundup. In this program, we bring you the latest legal news and detail of court proceedings.
India Legal presents Courts Roundup.
A public interest litigation petition has been filed in the Supreme Court seeking immediate removal of farmers who are protesting against the recently passed Farm Act from the Delhi-NCR border. The petition states that it is necessary to remove the gathering as the protest is posing hurdles for accessing emergency medical services needed to curb the spread of COVID-19 and to attend the patient in need of medical attention. A plea further states that life of lack of people protesting at Delhi border is at immediate threat since the virus is very contagious, and if by chance this coronavirus disease takes this shape of community spread, it will cause a havoc in the country. Plea states that roads have been blocked by the protesters, which has affected vehicular traffic, and people who are travelling to and from Delhi to get medical treatment in reputed government or private hospitals situated in Delhi are also affected. Two petitions have been filed in the Supreme Court challenging the Uttar Pradesh and Uttarakhand anti-conversion laws. Regarding the law, the plea states that it is against the basic structure of the constitution. Plea holds that the parliament or legislature can't bring about the changes in fundamental right. Here's a report. Two petitions have been filed in the Supreme Court challenging the constitutionality of the recently promulgated Uttar Pradesh Prohibition of Unlawful Conversion of Religion Ordinance 2020 and the Uttarakhand Freedom of Religion Act 2018. The petitions claim the laws made in the name of love jihad be declared null and void because it disturbed the basic structure of the constitution. The first petition filed by Advocate Neeraj Shukla said the law passed by the Uttar Pradesh government, which recommended 1 to 5 years of jail if any accused failed to prove the conversion of the woman was not for marriage, has resulted in the violation of Article 14, 15, 21 and 25 of the Indian Constitution. Right to live with a person of his or her choice, irrespective of religion, is intrinsic to right to life and personal liberty. Interference in a personal relationship would constitute serious encroachment into the right to freedom of choice of the two individuals. The petitioner has submitted that the true danger with the new so-called love jihad law lies not in the explicit textual basis, which seems fairly innocuous prima facie. Instead, its threat lies in its ambiguity. Although the scope has been cleverly restricted within constitutional margins, the law employs the use of open-textured phrases such as undue influence, allurement and coercion. The petitioner has thus asked for a direction in the nature of mandamus to the state government of Uttar Pradesh to declare the new law null and void, and instead direct the central government to pass any legislation on religious conversion or enact a new law on freedom of religion and conscience. The other petition has been filed by advocates Vishal Thackeray, Abhay Yadav and Pranvesh, a law researcher seeking a direction to declare the ordinances of the two states to be ultra-vires and direct authorities not to give effect to the ordinances passed by the government concerned. The petitioner have submitted that the ordinance passed by the state governments of Uttar Pradesh and Uttarakhand is against the provision of the Special Marriage Act 1954. Bureau Report. The Supreme Court has said that pendency of appeals by co-accused has no bearing on presidential pardon granted by a centre to death row convict. Additional Solicitor General had informed the Supreme Court that proposal of commuting death sentence was not sent to President as appeal of other co-accused was pending and that the convict himself has not filed an appeal. Here's a report. A Supreme Court bench led by Chief Justice of India S.A. Bobde said that once the central government has decided to recommend presidential pardon for a death row convict, then pendency of appeals of his co-accused in Supreme Court cannot be a reason to delay the process initiated under Article 72. The bench, which also comprised Justices A.S. Bopanna and V. Ramasubramanian, gave Additional Solicitor General K.M. Natraj 2-week time to take instructions on commuting the death sentence of Balwant Singh Rajauna, a death row convict who has been in jail for 25 years. Singh was convicted for the assassination of ex-Punjab Chief Minister Besan Singh. The Ministry of Home Affairs had, by its letter of September 2019, written to the Chief Secretary of Punjab that on the occasion of the 550th birth anniversary of Guru Nanak Dev Ji, release of some prisoners is proposed. Balwant Singh was among the select few. However, the ASG informed Supreme Court on Friday that the proposal was not sent to President since appeal of other co-accused in the case is pending and that Singh himself has not filed an appeal. The petitioner is serving imprisonment since 1996 and it has been 25 years he is in jail. Singh has served 13 years out of 25 under death sentence and total of 8 years of the President to decide his mercy petition. The petition before the Supreme Court submits that the delay by the executive in this case is inexcusable. The petition filed through Advocate Rupesh Kumar further stated that keeping the petitioner in suspense while consideration of his mercy petition by the President of India for more than 8 years is an agony for him, which has created adverse physical conditions and psychological stresses. Bureau Report. The Supreme Court has upheld the constitutional validity of imposing goods and service tax on sales of lotteries across India. The court has held that keeping lottery and gambling under GST's ambit is legally valid, upholding validity of tax imposition on lottery tickets and the prize money. Here's a report.
The Supreme Court has upheld imposition of goods and services tax on sale of lotteries. A 3-judge bench of Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah ruled that the Central Goods and Services Tax Act 2017 and the notification issued under the same ringing, lottery and gambling under GST net are valid. The petition filed by lottery dealer Skill Lotto Solutions had contended that lottery can be classified as goods, as has been done by the central government. The petitioners, including Skill Lotto Solutions Limited, had argued before the Apex Court that under the GST Act, rates prescribed on the sale of lottery tickets are 12% if the lotteries are sold within the same state and 28% if a state sells the lottery tickets in other states, which is arbitrary, discriminatory, unreasonable and clearly violative of Articles 14 of the Constitution. It was therefore alleged that imposition of 12% GST on lotteries sold within the same state and 28% GST for sale of tickets from other states was discriminatory. Instead, they can be only considered as actionable claims and lottery tickets by itself are pieces of paper devoid of any value. The centre had imposed GST of 12% on sale of lotteries within the same state and 28% if they were sold in other states. According to the petition, Article 52 of Section 2 of the Central Goods and Services Tax Act 2017 and notifications levying tax on lottery is violative of the fundamental rights and contrary to a judgment of Supreme Court in Sunrise Associates versus Government of NCT of Delhi of 2006, where it was held that lotteries could not be defined as goods and were merely actionable claims. Bureau Report.
The Karnataka government has moved the Supreme Court challenging the order of the Karnataka High Court whereby it has struck down the 25% horizontal domicile reservation at the National Law School of India University for students of Karnataka introduced by the state government on 27th of April. Here's a report.
The Karnataka government has moved the Supreme Court challenging the Karnataka High Court's decision to quash the National Law School of India University or NLSIU Amendment Act 2020, by which 25% domicile reservation was introduced at the university. The grounds for challenge are as follows. The public interest litigation filed by 2 alumni of NLSIU ought not to have been entertained by the High Court. High Court has expressly held that the Karnataka state legislature has the necessary legislative competence to pass the Amendment Act. High Court erred in holding that the Amendment Act usurps the powers of the Executive Council of NLSIU and is consequently contrary to the scheme of the Act. High Court has held that once a power is conferred on an authority by statute, the legislature is powerless to curtail that power or alter the manner in which such powers are to be exercised. High Court erred in holding the NLSIU is not an aided institution. State had filed extensive material before the High Court to show that NLSIU has been provided with annual aid as well as 23 acres of land on lease at a concessional rate by the state. High Court has also erred in observing that NLSIU is not a state institution and that is not within the control of the state. High Court erred in holding that the Amendment Act violates Article 14 of the Constitution. Based on the above grounds, among others, the state government has prayed for leave to appeal against the September 29 judgment of High Court. In interim, a stay on the Karnataka High Court order has been prayed for. While quashing the 25% reservation introduced at the university for students domiciled in the state, the High Court held that the NLSIU Amendment Act was ultra-vires and contrary to the provisions of the Parent Act. The Bar Council of India has filed the third petition in the matter. The plea states that the Karnataka government went ahead and enacted the Amendment Act without prior consultation with the BCI. Bureau Report.
The Supreme Court has observed that the dismissal of the special leave petition is of no consequence on the question of law. In this case, the division bench of the High Court set aside the single bench judgment that allowed the writ petition for the grant of 916 years time-bound revised promotional scale to the petitioner. The division bench had followed the dictum of the judgment in Bakrabas Management Board versus Krishnan Kumar Vij to hold the petitioners are not entitled to relief sought before the apex court. It was contended that some other employees have been granted benefit by virtue of the others passed by the High Court and the special leave petitions were dismissed. They pointed out that a writ petition filed by an employee junior to them as assistant civil engineer was allowed by the division bench of the High Court and SLP file against this was dismissed by the apex court. In Kunhayamad case, the Supreme Court has considered the legal implications and the impact of an order rejecting a petition seeking grant of special leave to appeal under Article 136 of the Constitution of India. The Madras High Court has issued a slew of directions for the conduct of inquiry under Section 1761A CRPC in cases of unnatural deaths in custody. Court has issued the direction in a plea move to exhume the body of a man alleged to have died following custodial violence by the Tamil Nadu police. Here's a report.
In the interest of ensuring transparency in cases involving allegation of custodial deaths, the Madras High Court has issued various directions including for the preservation of the body of the deceased and to ensure that the family has access to the body and the autopsy report. Given that the foundations of any democratic government rest on public confidence and acceptance, Justice G.R. Swaminathan observed, it is in the interest of the police to take the family of the deceased into confidence and avoid rushing things through. They are stakeholders in the process and the police have to treat them accordingly. In furtherance of this goal, the judge proceeded to issue the following directions to be followed in case of custodial deaths. The judicial magistrate conducting the inquiry under Section 176(1)A of the CRPC shall ensure that the family of the deceased or its representatives are given access to see the body and are also allowed to take videos and photos. No autopsy shall take place or commence without the next of kin having seen the body. The autopsy shall be carried out by a team of 2 doctors who have a master's degree in forensic medicine and are attached to a medical college and hospital in the state. The autopsy shall be done by adhering to the norms laid down by the division bench in E. Ishwaran versus Government of Tamil Nadu passed in April 2019. The whole body shall be x-rayed in order to find out if there are any fractures. The entire autopsy should be videographed from the start of the examination till its completion. The court has also detailed what are these phases in order, which includes the steps to be followed while video recording for autopsy. The autopsy report should be prepared expeditiously and handed over to the investigating officer in the case so that the filing of the final report is not delayed. Justice Swaminathan issued the direction and a plea moved to exhume the body of a man challenged to have died following custodial violence by the Tamil Nadu police. Apart from allowing the plea for exhumation, the court also directed that further investigation of the case be transferred to the CBCID in the interest of justice. Bureau Report.
The Karnataka High Court has issued notice on a petition which challenged the government decision to drop criminal prosecution in 61 cases against elected representatives and ministers. The High Court has sought government response in challenge to withdrawal of 61 cases against MLAs. The court said the public prosecutor cannot act like a postbox.
The Karnataka High Court has issued notice on a petition which challenged the government decision to drop criminal prosecution in 61 cases against elected representatives and ministers. A division bench comprising Chief Justice Abhay S. Oka and Justice Vishwajit Shetty observed, no court is bound by such a decision taken to withdraw from the prosecution, even if an application is made under Section 321 of the CRPC. The courts are duty-bound to assess whether a prima facie case is made out or not, and that the court has power to reject the prayer. The court was considering a petition filed by People Union of Civil Liberties Karnataka challenging the August 31 order wherein the government has granted permission for the withdrawal of prosecution of the 61 cases under the Section 321 of the Code of Criminal Procedure. The cases being withdrawn include the cases against the State's Law Minister J.C. Madhuswamy, Tourism Minister C.T. Ravi and Agriculture Minister V.C. Patil. Case from 2017 against Horsepete MLA Anand Singh is also sought to be withdrawn. Advocate Clifton D. Rosario, appearing for the petitioners, argued that the decision was against the rule of law. The court refused to stay the decision. However, it referred to the Supreme Court order in the case of S.K. Shukla and others versus State of Uttar Pradesh and others, which held that even if government instructs to the public prosecutor to withdraw from the prosecution of a case, the latter, after applying his mind to the facts of the case, may either agree with the instructions and file a petition before the court stating grounds of withdrawal, or disagree therewith, having found a good case for prosecution, and refuse to file the withdrawal petition. The decision also observed that in the event the public prosecutor disagrees, he will have to return the brief. It further observed that the public prosecutor cannot act like a postbox or act on the dictates of the state government, and he has to act objectively as he is also an officer of the court. The court said that the public prosecutor should invite the attention of concerned court to the observations of the High Court when making application under Section 321 of the CRPC. Bureau Report.
Well, that's all in Courts Roundup. Thank you for tuning in. Keep watching APN.
India Legal presents Courts Roundup.